you guys hear me back there? You good? Okay. All right. So both Corby and Johnny asked me to speak on this topic, these new ADA claims for this conference, and I thought, all right, that's great. For once, I don't have to lecture you guys and talk about how to fire people. It seems like that's all I'm talking about lately is how to fire people, what to do, what not to do, that type of thing. So we're not going to talk about firing people today, but my goal, and I can probably pretty much almost guarantee you that you guys are going to walk out of here today shaking your head. Just no, yeah. And in fact, this isn't really going to talk about your employees, which is also a little bit different from what I usually talk about. But I find it fascinating, and I really want to kind of delve into what we're seeing a trend on. Now, we've talked about before the ADA. Everybody here knows what the ADA is, right? Raise your hand. Raise your hand if you don't know what the ADA is. Okay, we'll talk afterwards.
No, I need ADAs.
Alright, well, so does everybody else, as we've talked about before, right? Everybody qualifies for the ADA. We're not going to talk about today the ADA, believe it or not. Okay, we're not going to talk about what qualifies for the ADA. We're not going to talk about your employees who may or may not qualify for the ADA, and if they make a claim and what to do, and FMLA, and all those things that you've heard me talk about before. What we're going to talk about is how these claims are developing and what we're starting to see. And actually, there's some good news at the end, kind of what we're doing to shut them down. So let me just kind of set the stage on where I first got involved in these type of ADA claims. And I'm going to call them drive-by ADA claims. Anybody ever heard of a drive-by ADA claim? Okay, a few of you guys. Okay, that's what we're going to talk about today. We're going to talk about drive-by, and then we're going to talk about computer ADA claims. So we'll get into that in a minute. So about a year ago, I just want to kind of set the stage. We at our firm, we monitor when lawsuits are filed, right? So I kind of know if any of your counties are sued, and then I give a little phone call to Corby and I say, hey, just give me a heads up, you know, Cache County was just sued. Here's a heads up. Or something like that. Not that I ever had to do that for anybody in this room. But I see that various counties are sued, or I see that some of my clients are sued. Now, I have not seen any of these cases apply yet to a governmental entity. A, it could be coming, but B, the reason that we want to talk about this today is because I think it's going to provide some invaluable information for you all, for the people who live in your counties. Okay? So, I'm setting the stage. I'm seeing lawsuits that are filed, all kinds of lawsuits. Generally, about 20 lawsuits or so are filed throughout the state each day. And we just give a list of them, who the plaintiff is, who they're suing, and a basic little summary of what the case is about. And all of a sudden, we start seeing an individual named Carolyn Ford. Anybody ever hear the name Carolyn Ford? Okay. So we see Carolyn Ford bringing a lawsuit against McDonald's, Carolyn Ford bringing a lawsuit against Taco Bell, against Target, against, you know, John Smith Chinese restaurant, against Denny's, and it just goes on and on and on. And she's bringing about 20 or 30 lawsuits a day. Okay, and we're like, holy cow, who is this Carolyn Ford? And they're all ADA lawsuits, saying that she is a disabled person and that these businesses are not complying with the ADA. Not me. Okay, all right. So as you know, with the ADA, there's certain regulations that you have to follow, and there's a whole list of them. But these lawsuits were all focused on the outside of a business. So think the parking lot, right? Parking lots, you've got handicap stalls, right? You've got to have a certain number. They need to be a certain location. They need to be a certain slope for wheelchair access. And then there are handicap signs. They need to be a certain height pursuant to the ADA. There's certain regulations, right? So I happen to get a few Carolyn Ford cases for a few of my clients. A couple McDonald's, some Denny's, etc. I get the lawsuit. I call up counsel to say, hey, can I get an extension to file an answer? It's pretty standard for what you do. And he said, sure. What we'd like to do is we'd like to try and get early resolution of the case. All right. He said, meet me out at this McDonald's. And these Carolyn Ford cases, so you know, were mostly in Utah County. All right. So he says, meet me at the McDonald's. And I said, great, then I'll meet you at the Denny's right after that because we have two, okay? And he said, sure. So, and I looked, and the person I was meeting with, I forgot his last name, but I looked at his law firm, and it was with one of the last names being Ford. Carolyn Ford, and also this was one of the lawyers, Ford, all right? So I meet the guy down there. He shows up. He's got his baseball cap on, his wrinkly shirt, and his jeans. And he shows up. He says, yeah, I'm the lawyer. I said, okay, great. Nice to meet you. He says, I don't want to go inside the building. He had no interest in going inside the restaurant. He said, I just want to show you what we think needs to be rectified. All right? He says, see this sign here? He said, it needs to come up 2 inches. Or he said, see this slope here where the wheelchair access is? It's too great of a slope. See, I've got my little handy-dandy slope meter that I picked up on Amazon.com, and literally, this is what he's telling me, and he shows me that the slope it's too steep for somebody in a wheelchair by, maybe an inch. And so he says, here's a list of the things that we feel need to be corrected. Okay, and they were in violation, technically, of the ADA. That they were in violation. He says, make those changes. We'll give you 6 months to a year to do it. No real rush. Also, there was no proof that Ms. Ford had ever been in these establishments. Of course, she says in the complaint, those McDonald's cheeseburgers are her favorite, and it just tears her up that she can't visit that establishment. But he says, and then we just want a nominal sum for attorney's fees for all of the difficulty we had to bring this lawsuit. Well, how much do you want there? Well, we want about $3,500. So I go back to my client and I say, these are the changes that need to be made. They say, are we in compliance? I said, you probably aren't in compliance technically. Okay. And they want this $3,500 in attorney's fees. Realistically, as any of you know who've been through lawsuits, settling a case for $3,500 is dirt cheap, right? Okay, if any of you have been sued, if you get a chance to settle for $3,500, it's probably a pretty good idea. In fact, Corby's shaking his head back there going, yeah, I'd settle for $3,500, okay? So my clients say, sure, we'll enter into the settlement agreement. I walked away from those cases. I probably ended up having about 5 or 6 with a bad taste in my mouth, like this is a real scam. It's a real scam. Left a bad taste in my mouth. That ain't nothing, guys. Okay. Carolyn Ford actually exists. She actually has a disability. I don't know quite what it is. I think it's some kind of an anxiety disorder or something. I don't really know, but technically she has a disability. When it got ugly is when we started to see other lawsuits. Carolyn Ford kind of ran her time. Some of you, anybody see on the news the article? It was like a get part about Carolyn Ford. Anybody see that? Okay. So as soon as that ran, it was kind of interesting. All the Carolyn Ford suits kind of stopped. We don't see those anymore. But what did start were 3 other plaintiffs. And I'm going to talk about those a little bit later. But we started to see those in the same frequency, if not more, than Carolyn Ford. And I thought, okay, so those lawyers learn from Carolyn Ford. I mean, I'm naive, right? Okay, I'm a lawyer. I'm naive. They must have learn from Carolyn Ford. They're not in Utah County, they're going north, or they're going south. So they learn from those other lawsuits, and they're going to try and capitalize as well. So what happens? I end up getting a couple of those cases. I contact the lawyer via phone to say, hey, knowing what had happened in Carolyn Ford cases, hey, can we talk about this? Can we maybe get an extension before we have to file an answer and go through the whole litigation process? Well, unlike Ford and Crane, that was the name of the other law firm, Carolyn Ford, unlike that, I got a recording from the law firm saying this is the disability law firm, and the best way to get a hold of us is via email. We won't answer our phone calls. And I thought, that's really weird. I mean, if you guys know, it's hard to get a hold of a lawyer on the phone, but at least there are living, breathing people, and you can at least leave a message. And they said, don't leave a message, just send us an email. So I thought, that's really bizarre, but okay, I'll send you an email. Send an email, and immediately, within probably half an hour, I get an email back that says, yes, we'll give you the extension, and then it started with this letter. Please be aware that our client has this particular disability, and she went to your establishment, but we're willing to settle the case. Now, they haven't even been out there. We didn't have that meeting like we did with Carolyn Ford, but we're willing to settle the case for a nominal sum of $3,900. Please let us know. And I thought, well, gosh, these guys are even lazier than the other ones. They don't even want to go out to see the site. So I tell my client, I said, well, I got this letter, and they're willing to settle it for $3,900 and make the changes, and I had it with this Carolyn Ford, and it worked, and that's a pretty good deal. If you guys want to fight it, we can fight it. And the first couple that I got said, yeah, let's go ahead and settle. So we did that, and it was really interesting because each case I got the same phone call. We only accept email. I got the same email back. I thought, this is really bizarre. And then I ended up having 2 cases for the same company, 2 7-Eleven cases, different locations. And I thought, this is just not really passing the smell test. Did a little bit more investigation, and I started to learn some things in connection with some other legal counsel throughout the state. And that's what I want to talk about today. So first, what we're going to do is go red.
Green is good.
Green is good.
This is all about parking lots, and disability access. Under the Americans with Disability Act, businesses need enough space between spaces, proper signs at the proper height, and that little band notice. From this one, be just an inch off, and there's a new group who will sue and demand thousands to settle. They say it's advocacy. Others call it extortion. You watch, and you decide.
No, this
This is Advocates for Individuals with Disabilities, AID for short. Founded this year, their videos show them handing out things like a special brace, a scooter, and a window AC unit. There's nothing controversial about that. But what is controversial is how they make money. It's with lawsuits, hundreds and hundreds of them, bringing in millions of dollars. Lawsuits filed by AID, along with this man.
As disabled people, we don't have a voice.
David Ritzenthaler is 74, had hip surgery last year. A self-proclaimed minister.
Listen to what God had to say.
He considers his lawsuits for AID public service.
And I said, I love what you're doing.
Ritzenthaler's filed 530 lawsuits this year. Restaurants, banks, offices. This minister even sued this strip club.
He's a committed individual.
Peter Stroynick is attorney for both David Ritzenthaler and AID.
David Ritzenthaler gone to all 500 of those businesses?
No.
But he's the plaintiff.
Yes. And the question is?
So he doesn't have to go for you to sue the business?
Absolutely correct.
Really?
Yeah.
Critics call them drive-by lawsuits because aid staff cruise parking lots looking for violations. This auto parts store got sued. Why?
I didn't have a van accessible sign.
For that, owner Bob Curtis says aid wanted $5,000 to settle.
Yeah, $50 sign for $5,000.
To me, it's extortion. Is that really an accessibility issue that requires a lawsuit?
Oh, yes.
To aid, any violation is discrimination, and they plan to file 100,000 of these lawsuits across the country.
The purpose is to do something incredibly good. We are trying to affect a change. We don't want more lawsuits.
But Phil Pangrazio says they're hurting, not helping. So does John Moore
Harms all of our efforts.
and Larry Wayner.
And abusing the law.
These well-known advocates run 3 prominent Arizona disability organizations.
High-frequency lawsuit filing is giving the ADA a bad name.
They really are distancing themselves from you guys. They don't have anything to do with you. What do you think that says?
Well, that says that we are probably going to be the most effective advocacy group of any advocacy group that had ever been established.
And that seems ironic,
So this is where they do business.
because at the parking lots for 2 buildings where aid operates, we found low signs, 41, spaces with no signs.
2 spots coming up.
Around this entire building, not a single van noticed, including the spot
We're missing the sign.
right in front of Aid's store. There we also found faded paint and a ramp overrunning and blocking the access lane.
I'll have to check on that.
That's not good.
A big violation, says ADA compliance expert Peter Fisher.
Or are they in compliance, yes or no?
No,
Keep it close.
no.
And when we went inside to ask Aid about the parking lots, out came their spokesperson, Jennifer Rogers, and Alex Callan, a legal assistant.
We checked both this location and your other location where you guys have the check sent, and neither one of them are in compliance with the ADA. I don't know if you guys knew that.
I don't know if you know that, but this is not a building of public accommodation.
That's why Aid says this building doesn't have to comply. But our expert disagrees, and Aid must be worried about us checking.
58, that's
Because
what
they sent out this employee to film us and walk with us until she broke her shoe. Ended up barefoot. She then got in her car and started filming while driving, at points swerving close to us.
We don't want you to hit us, so we're gonna go in this spot area, so I don't know what you need to do to work around this, we just don't, okay, thank you. Here's where the people use their phones and driving a little bit, so
And all this really comes down to one thing.
we're gonna sue other businesses for not having these access issues. You brought people to this building who have disabilities. You don't think that maybe that, you should hold yourselves to the same standards as the places you guys are suing?
You guys like to leave?
And when we left, they left us with this final thought.
Your story is garbage news, and you're making an embarrassment of the station.
So, garbage news. Let me tell you about what we found out and what has been happening now in Utah. We'll kind of go back and forth between Utah and Arizona. So what we've learned is that, first of all, all of these suits began originally in Arizona with this aid company. Okay? It's fake news. So we've got the evolution of aid. It started back in the summer of 2016, okay, back in Arizona, and there were a number of these lawsuits that were filed. It eventually got to the attention of the Arizona Attorney General. And the Arizona Attorney General consolidated a lot of the cases and ended up getting those cases dismissed. After they stopped working in Arizona, then they started working in Colorado and Nevada. Then it went to New Mexico, and New Mexico is where it started to get really ugly. After New Mexico, it's now come to Utah. So what happened in New Mexico, which is, as a lawyer, I think it's just fantastic. They started to bring all of these cases. Now let me explain what came out in New Mexico that was learned. There would be this company that's AID, or there's also another company with, it's called the Litigation Management and Financial Services. AID and Litigation Management and Financial Services are not run by lawyers. These are not lawyers out to help people. These are groups, not groups of individuals who are disabled. They are financial groups. They are groups who have created essentially a way to scam people. What do? They go on Craigslist and they run an ad for disabled individuals. And they offer to pay disabled individuals to ride in the car. They pay them to get in the car, they take them for a ride along so they can say that they've now been to these institutions. And literally, they go next door, one to the next, to the next, to the next. They then sign them up as plaintiffs, and they recruit lawyers. In Utah, they have recruited about 3 different lawyers. So you can see about 3 different law firms, so one's a little bit more aggressive than the other 2. And they also have recruited about 3 or 4 different plaintiffs. From the New Mexico, what happened in New Mexico is they kind of were starting, the lawyers, they were putting 2 and 2 together. And they realized after like about 150 cases, okay, what is going on? So they got them consolidated before one particular judge. And when one particular judge sees exactly what's going on, and it was either he or she said, okay, something fishy is happening. So there was a hearing that was held. And during that hearing, the judge put the plaintiff under oath. That person admitted that she had never been to these institutions, that she was recruited on Craigslist, that she was paid $50 for each lawsuit that she allowed her name to be put to. And then there was questioning of the lawyer involved. And I mean, can't you just picture it? You've got this courtroom, there's about 50 defense lawyers there and 1 plaintiff's lawyer. And the judge starts quizzing down this lawyer. And it came to light where she made him produce the contractual agreement that this lawyer had with this aid company, with these non-lawyers. And essentially there was a financial agreement that the lawyer would allow his name to be used in these lawsuits as counsel. And the lawyer made $100 for every time he filed one of these lawsuits. So you got the plaintiff that's being paid $50 a lawsuit, you've got the lawyer who's being paid $100 a lawsuit, and guess who gets the rest? This company. Okay? The company is out of Arizona. Guess what company was communicating with me through my emails on these new filings in Utah? It's the same thing. Okay? So what happens is these companies who are not they're practicing law without a license. They're soliciting clients, which you're not allowed to do. They have these agreements with lawyers, and you tell me if this would be a problem. We were starting to put these things together in that the lawyer, these 3 lawyers, had a different email address for their other cases. They had a different mailing address for these other cases. So wherever we're sending all this stuff for these ADA cases is not where they do their real business, because everything's being funneled to Arizona. So let's see. 2017, we get ADA lawsuits. We've got the Carton versus Carroll Ventures. This is the case in New Mexico that reveals all of this information. Okay? So let's see. What is their business model? They say, to profit from ADA litigation has given birth to what one court has described as a cottage industry. You have an unscrupulous law firm send the disabled individual to as many businesses as possible in order to have him aggressively seek out any and all violations of the ADA. Then rather than informing the business of the problems, okay, giving them a call saying, hey, you know what? You've got these violations. Instead, they filed a lawsuit. As soon as the company gets this litigation, they think, oh no, what do? They quickly settle for the standard it's about $3,900 is the standard email that they're given. So you've got plaintiffs, these disabled people who are essentially pawns. The lawyers themselves, I think, are pawns. And you've got these companies who are making a heck of a lot of money for these practices. So we've got Alyssa Carton, 99 lawsuits. Like I said, the cases were consolidated, a dismissal was requested, the magistrate held the hearing. 30 attorneys, 46 defendants, questions the plaintiff. The magistrate ordered the disclosure of these secret agreements between the plaintiff and the lawyers. $50 per case, attorneys were paid $100 per case. What happens? The New Mexico cases go away. Okay? The judge dismissed the cases. And in fact, what ended up happening, see, these plaintiffs also plead poverty. They say that they don't have enough money to pay for the filing fees. So it's the state or the federal courts that are essentially waiving all of the filing fees for all of these hundreds and hundreds of cases. And that really ticked the judge off in that. In fact, I believe that they had to pay back, they were fined and had to pay some of these fees back. So who are the plaintiffs in Utah that we know of right now? We've got Samuel Birmingham. We've got at least, and this was as of probably a month ago, 120 suits. Tammy Shelton, 22. Trevor Kelly, 107. Okay. All of them are believed to be supported by this litigation management company. Every single complaint is identical. It's copy and pasted. In fact, it's really interesting because Sam Birmingham, some of them will say that he's a resident of Spanish Fork, if it's, down in that county. Other times it'll say he's a resident of Logan, if it's up in Cache County. He moves around a lot. But these lawsuits are literally cut and pasted. The demands are literally cut and pasted. Special contact information, and then you've got the standard $3,900 settlement offer. So who's the real plaintiff in the case? Is it the disabled person? I don't think so. Do they even have standing to bring the suit if they haven't been to the location? I don't think so. Who pays for all of it? Well, so far it's been businesses. So here's what we've been doing as a group of defense lawyers. We actually got together and said, hey, are you handling these cases? Hey, are you handling these cases? Here's what we've learned, and we've taken a strategic approach. So what we do is we file what's called a motion to consolidate, letting the judge know that, you know what, there were these cases in New Mexico, there were these cases in Arizona, this is what the Arizona Attorney General did, and Your Honor, this is what's happening in your courtroom. And here's all this information. Let's consolidate all 100 cases. And we had a hearing about, a month ago before one of the magistrates in federal court. She was not very happy. I believe that she is going to consolidate the cases and will likely dismiss them. We've also approached the Utah Attorney General's office, who is investigating it. And we've also approached the Utah State Bar. Some of the lawyers I've seen have been withdrawing. A couple of them, and then one in particular is taking over for them. He's kind of the more aggressive one. And it'll be interesting to see what happens there. We had a case this last week that, because what they plan on is that you'll just settle. So So if you actually answer the complaint, then that means they have to do some work, and oh no, then there's a scheduling conference. Well, we had a scheduling conference and the lawyer didn't even bother to show up. So we're hoping that this, now that these cases, that, you know, the scam is up, the gig is up, these lawsuits will be dwindling. We haven't seen as many being filed. There still are some that are being filed. But what I wanted to educate you all on, so far, like I said, I haven't seen them say, you know, we went to this county building and the signs were a half an inch, you know, too low. But certainly, if you have your small businesses, and it's small businesses, it's large businesses, they don't care. I've seen it where it's literally, you know, a one-man Chinese restaurant, little family business, and then right next door is the Denny's, and they sue them both. And so they don't care. And unfortunately, you know, for the Denny's, it kind of stinks, but for the very small Chinese restaurant, it hurts to have to come up with that kind of money. So we hopefully got the wheels rolling with that, where it won't be as much of a problem. But if you do see anybody in your counties that are hit with these lawsuits, if you hear them talk about it, you can educate them that they need to fight it, that if, you know, you can give them my name or whoever, and let them know that this is truly a scam, and that it's not what they think it is. Believe it or not, we've heard that Congress, and of all people, okay, we've got the California Congresswoman, I forgot her name now, Dianne Feinstein. She is actually sponsoring a bill to go before Congress to talk about these ADA lawsuits, to say that, look, they shouldn't be able to just bring a lawsuit for money. What needs to happen is there has to be some type of communication at first to say, look, you're not complying. I'm going to tell you what the problem is and give you an opportunity to comply. So that way you mitigate, and then the problem is solved, and it just kind of takes all the wind out of the sails for these companies. Because that's another thing that's happening is the companies, when they're sued, they'll make the changes really quick, and then we say to the court, look, it's moot. There are no damages that are owed. The changes have been made. The problem's solved. Case dismissed. And they don't really care if the changes are made. They just want their $3,900 fee. So that's the ADA drive-by. Another thing that they can do, that you can have the companies do also is report to the IRS. The IRS would have some interest in this. Also talk to the State Attorney General's office on that. So that's kind of the drive-by. On the PowerPoint, I don't have anything on the PowerPoint on the computers. But let me tell you, there's a whole other avenue for drive-by ADA litigation. About 6-8 months ago, I got a phone call from one of my clients and said, Kristin, I just received this letter from a law firm back in Connecticut. And can you tell us what's going on? So I looked at the letter, and it basically said, you are in violation of ADA, the ADA, in that this was a retail establishment. And it was a retail establishment that had a brick and mortar building, but also sold goods on the internet. Okay, so lots of retail establishments do that, right? And this company, or this law firm, said that you are in violation in that your website is not ADA accessible. And I said, so I called them up and I said, what in the world are you talking about ADA accessible? Well, blind people and deaf people can't go online and buy their goods and services. And I said, are you kidding me? And I said, will you show me what regulations there are that require these websites to be accessible for the blind and the deaf? And they said, well, the regulations are in progress right now. But by the time they're enacted, your client will be in violation and there will be significant penalties that are owed. And I said, well, you let me know when those are enacted and if there are penalties that are retroactive. And they said, oh, well, we're going to give you an opportunity to resolve this now. And I said, and what opportunity would that be? Well, we can retrofit. We have companies that can retrofit your entire website. And I said, well, we can have our own IT people do that. Oh no, they won't be able to do it technically like these experts. But these experts are quite pricey. It might take about $100,000 to $150,000 to retrofit your website. So, but we have to use your experts. Well, we would highly recommend that you use our experts. And then we would, of course, want an attorney's fee for giving you this information, getting you to the expert, and in order for us to give you a release. And we can guarantee that if other plaintiffs come forward, that we'll protect you and we won't have anybody else sue you for violation of the website. But we only want about $80,000 for that. And I basically sent a letter saying, thank you, but no thank you. Point me to a regulation that's been enacted, and then we can talk. Needless to say, I have not heard anything else. I did a little bit of researching though, and this law firm out of Connecticut has literally filed or sent hundreds and hundreds, close to 1,000 letters to businesses all throughout the nation for this extortion. And to date, I don't know if any actual lawsuits have been filed, but as of right now, there are no regulations. There might be some that are in the works, but there are no regulations that require you to have a retail business online that it be accessible to the deaf and the blind. So that's just kind of another kind of scary twist that makes you want to shake your head for people that are trying to scam the system. As I was watching the last presenters, with those scam artists, this to me falls right in that, but yet they're trying to use the law to scare you into paying a settlement and to giving a release for something that the law doesn't even require. So that's the presentation. I think I'm about on time. I may be a little early, but yeah, I'm willing to take any questions you've got.
So, as far as disseminating this information, how much of the information should I was thinking we were just talking about like giving it to our chambers.
I think that, sure, absolutely. I think that the chambers should be aware of this. If anybody wants a transcript of that New Mexico hearing, I mean, it's a long transcript, but it's public records. It is not protected. It is not subject to a protective order. And so, it's fabulous reading where the judge is literally just reading a riot act to these lawyers, and they're stumbling all over themselves and making them, I mean, how often do you see a judge make a lawyer produce his contract, his confidential contract with the company? It does not happen. But she required that, and so I believe we actually have copies of that contract. Now again, it's not Utah, it's New Mexico, but we believe it's the exact same thing because it's the same language in our cases that's being used there. So, but I'm happy to provide that. I think getting that information to the chamber would be a great idea, so they're aware of it. So if any of their businesses have these problems, have these issues, they'll know how to handle it. Any other questions?
What's like the difference between this versus like the no money or get a lawyer if you have something to do on
Those are class actions, and they actually, what they'll do is, that's, like for the MISO cases, or for FenFed cases, or all of those type of things. What they do is they actually have a single law firm in the nation that they don't handle all the cases, but they are kind of the collection zone, and then they'll enter into agreements with local counsel that can kind of run the various asbestos cases and that type of thing. Most all of those cases end up settling, but I can tell you there's a lot of litigation with a lot of lawyers and a lot of defense lawyers as well for depositions and all kinds of things that just rack up the bills, but then they end up getting settled. There actually are plaintiffs there, but yeah, they are soliciting, but they're not getting paid $50 to lend their name to a lawsuit where they haven't even been to the place of business. So I think that's kind of the difference. Any other questions? All right, here we go. Thank you.
And that still scares me because what happens in New Mexico doesn't necessarily follow suit in Utah. And I know that a couple of you have been involved with cases that we've had that we have a few judges here in Utah that I'm not so sure would rule the same way as that magistrate did in Mexico. I don't want to use the word activist, but it would be the correct term to call some of these judges that we have right now in Utah. So, you know, they may not decide on a larger scale that that these groups aren't doing a great public service by protecting disabled people through these lawsuits. The other concern that I'd have is they may see that they need to protect businesses in their community from it, but that maybe it's a necessary thing to assure that government is going to follow the rules, and that they'll shut down the cases against businesses, but when they're against governments, we need to have that happen because that's the only way we can protect people and make sure that governments, is it just me, or do other people get the feeling that people are against local government right now? That they feel that you don't do anything right, that you have no interest in doing things right and complying with the law. It's really unfortunate because I know how hard all of you work at being in compliance and serving your constituents well. So it still scares me.
Yeah, and I think our best defense, even against activist judges, is to say that, look, we are willing to comply, we're willing to make the modifications. They haven't asked, and to show, you know, just kind of the trend and to show what Congress is trying to do, just to have that dialogue that we're not trying to not comply with the ADA, we're happy to make those changes. It's the extortion, and when we consolidate all the cases, that's when it really hits that, oh my gosh, there's 150 cases by this single person. It makes a lot more of a difference. Most are also in federal court. So that's a good thing.
Right. Yes. So, you know, I joked about Corby being Dr. No, and I don't always mean that. You know, when he's talking to you guys, I think most of the time you're not getting no's from Corby. I mean, again,
we're telling people to say no.
Yes.
Yes.
Yeah,
Thank you.
He's asking us what we want to do.
But this is a no answer. When we get these types of claims in, well, almost any type of claim, where people are looking for a quick and easy nuisance settlement, that's an absolute no. And you know, our history over time has really helped that people know that if I'm going to bring a lawsuit against the county, especially the big law firms in Salt Lake, just don't sue you guys anymore because they know that they've got to have a good enough case to go all the way through trial and win if they expect to get a dime. And most of them are not in that business. They're in the business of scaring you enough to offer a good settlement. And we just don't do that unless occasionally